Hello, and a warm welcome to the EDRM Global Webinar Channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with our trusted partner, eDiscovery Today. It's called Important eDiscovery Case Law Decisions for September 2024 with our faculty experts, Doug Austin, Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the council. Questions will be answered both during and at the end of the webinar. And this webinar will be available for replay at your convenience for the next quarter, as are all of our EDRM webinars. Kaylee Wallstead, EDRM's Chief Strategy Officer, is here. Can you please tell us what resources are available for our listeners, Kaylee?
Absolutely. And this is my absolute favorite monthly presentation. 4+ years going strong. We're also loving on 24 with so many more ways for you, our audience, to engage. If you check out your console to the right of your screen, you'll see the question mark icon. This is where you can type in your questions for today's faculty. As Mary said, slides will be made available after the webinar has concluded. You'll also see the paperclip icon. That's for related content. And if you click on it, you'll see today's resources carefully curated just for you. There's an On24 engagement tool description for you to download to help you better engage with the platform. There's also a link to subscribe to eDiscovery Today. And let me tell you, never miss a thing. It's my favorite way to start the day, and I give Doug Austin a big hat tip. There's also a link to learn more about the Honorable Judge Peck and how you can engage with him. You will also see another link, and that is for you to check out and order your copy of Tom O'Connor's spicy, newish book, eDiscovery for the Rest of Us, recently updated in collaboration with EDRM's trusted partner, NextPoint. And be sure to save your seat for next month's spooky case law edition on October 31st. And up next on EDRM's webinar channel this week, September 19th, Data Risk and Resilience, Part 3, Digital Forensics in Your Incident Response Plan. It's Part 3 of 4, and be sure to save your seat for that. They have put together a great masterclass. Speaker bios can be clicked and popped up to learn more about today's faculty. And then just like Zoom, it's our favorite thing. You'll see the smiley face emoji, and if you click on it, you'll see many more reactions that you can click during the webinar, and we highly encourage you to engage with them. The speakers love it, and we're having a lot of fun with them on the platform. If you click the Twitter bird, that's for social media. You can follow EDRM and eDiscovery Today on LinkedIn. And back to you, Mary.
Oh, thanks, Kaylee. And our speakers today, Doug Austin. He is the founder and editor of our EDRM trusted partner, eDiscovery Today, and an established eDiscovery thought leader with over 30 years experience, providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and government clients. Doug has published a daily blog since 2010 and has earned J.D. Super Awards 3 times. Tom O'Connor, the director of the Gulf Coast Legal Technology Center, is a nationally known consultant, speaker, and writer in the area of computerized litigation support systems. Tom's consulting experience is primarily in complex litigation matters, where he's worked with firms of all sizes, and most recently, the plaintiffs in the BP litigation. He's also been appointed as a technical consultant by various federal and state courts on cases dealing with large amounts of electronic evidence. And as Kaylee said, the most recent edition of his popular book, eDiscovery for the Rest of Us, is available, and you can find it in the resources to click on it. And we also have with us the Honorable Judge Andrew Peck, who is a Band 1 Chambers ranked senior counsel at DLA Piper, where he advises on copyright and trademark matters, and also serves as a resource for the firms and its clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck retired as a United States Magistrate Judge in the Southern District of New York after 23 years, writing many of our first and most significant eDiscovery opinions. EDRM is very grateful to all three gentlemen for their service on the EDRM Global Advisory Council and their work on this wonderful webcast, now in its fourth year. Without further ado, over to you, Doug.
Thanks, Mary, and welcome everybody to our September 24 case law webinar on the EDRM network. And we do indeed have another 6 unique cases to discuss this month, the last 5 of which were suggested by Judge Peck. And those cases address disputes related to form of production for photographs, cross-border discovery requests from non-parties, ESI protocol provisions on privilege clawback and TAR, responsibility for data privacy protection costs, waiver of privilege and 502D orders, and sanctions for spoliation of cell phone ESI and signal messages. As a reminder, we do welcome questions, and we'll try to get to as many as we can. And we'll send out a copy of the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. Unlike signal messages, disclaimers never disappear. And before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistant site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has nearly 38,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So with that said, let's get into the cases. In our first case, the plaintiffs claimed their constitutional rights were violated when the defendants obtained and executed 2 search warrants in connection with an arson investigation, and the defendants disclosed several hundred photographs that were taken during those searches. During discovery, plaintiffs learned that these photographs were originally stored in the Tucson Police Department computer system, and each image had metadata associated with it that was not included in the photographs that were originally disclosed to the plaintiffs. They also argued that this metadata should have been disclosed at the beginning of the case because this action was part of the mandatory initial discovery pilot project, which requires each party to disclose ESI, among other things. Many of the photographs were apparently originally disclosed through a separate state civil action that the plaintiffs brought pursuant to the Arizona Public Records Act. In analyzing the request, Arizona Magistrate Judge Michael Ambry stated, "It appears that the photographs and their metadata should have been part of the defendant's initial discovery disclosure," while also footnoting that discovery in this case was originally limited by the law enforcement investigatory privilege. This privilege was later abrogated by the court, at which point the defendants should have made an unredacted initial discovery disclosure as required by the MIDP and FRCP Rule 26A if they had not already done so. He also addressed the defendant's arguments, stating the defendant's position that their failure to raise the issue before now must be a strategic decision. The defendants do not opine, however, on what advantage the Moors might hope to gain by this alleged strategic decision. The defendants further argue that placards were filled out by the police officers who took the PDF photographs to indicate the beginning time for the taking of every specific group of photographs. Photos of the placards presumably were disclosed to the Moors. The court does not agree that these placards are a good substitute for the metadata. So finding that the metadata appears to be relevant and should not be too difficult to retrieve, he granted the motion to compel, but not the rest of the plaintiff's motion, including the request for sanctions. So Tom, what is the mandatory initial discovery pilot project in Arizona, and what does it expect for parties in discovery there?
Well, this one kind of threw me for a loop because I was familiar with the MIDP. I got to say, just as an aside, though, I really love the affirmative defense that we got placards instead of metadata. That is going up on my craziest pleading ever Hall of Fame award on the wall here. No, we got placards. We'll give you the placards.
There we go.
We don't need no stinking metadata. So the MIDP, there were actually 3 of them, and I say were because it's really interesting and why I was puzzled. The Northern District of Illinois, which is the one I was familiar with and had some discussions with people when that kicked off, the District of Arizona, and a third one run by Judge Lee Rosenthal in the Southern District of Texas. And they were basically designed to study, if you will, whether there was a need for some accelerated responses instead of standard discovery requests before entering other discovery, and would that reduce costs and delays in civil litigation, and all to further the FRCP1, just, speedy, and inexpensive. The FJC launched the program. Now they launched it in the spring of 2017, and it only ran for 3 years. Mm-hmm. So I'm no mathematician, but it expired in 2020. So I was curious as to how the judge said that it still applied here, or should apply here, and then found out in making some calls. I thought, well, had they extended it in a local rule or whatever? I actually was talking to Craig Ball, since he's still practices in Texas, and he did a little poking around while we were on the phone talking to each other. He said, well, this is interesting. The original warrants were served in 2017, and this case was filed in 2019. So the case fell during the time frame that the MIDP was in effect. And then the judge specifically said, yeah, in his order, he noted it's clearly under the purview here. An interesting note is that when a case was under an MIDP, an order went out from the court alerting all the parties to that. So you can actually see in the docket very early on, you're under the purview of the MIDP. The warrants were served in 2017. The case was filed in 2019. That's what it does, what it's designed to do. I don't know what ever happened, and maybe Judge Peck might even know. Did a report from any of those pilot projects ever go to the FJC? Did anybody ever comment on it? I should note that in that order that I just mentioned that goes out to the courts, it says, please note, this is a quote from the order, the discovery obligations in the MIDP supersede the disclosures required by Rule 26A1. So it was basically a let's try things a different way in this pilot project, report back, and then it just seemed to have, all of them seem to have just fallen off the face of the earth, except for cases like this, which have dragged on for a variety of reasons. I think Mary and the judge are going to discuss. And so the MIDP still applies to this case. Woof.
Well, that was a lot of good info. Well, yeah, a lot of good info, and I had wondered about the MIDP, whether it was still in effect, but obviously that it certainly explains it in terms of the length of this case. I also did not know that there was a pilot project in the Southern District of Texas, which is to my chagrin because that's my home area.
Yeah,
but
they were all very quiet. You know, mm-hmm. The one in Illinois, I mean, they were supposed to get some feedback from parties, and obviously in this case it didn't help speed anything along.
Right. No, certainly didn't. So,
yeah, I mean,
so Judge, go ahead, Judge Peck.
The little bit I know to answer Tom's question is that I think there were reports to the Rules Committee or the FJC. Not that I've seen any. So I don't know what that means. But the scuttlebutt is that the pilot program went well in Arizona because it conforms with Arizona state law discovery processes. Uh-huh. It did not go nearly as well in Illinois, where most people were, opting out of it or or whatever, including some of the judges. And I didn't know until what Tom was saying about Judge Rosenthal's process there, so I can't comment there.
All right.
Yeah, when it started, sounded really promising, and then it just sort of withered away.
Yeah. And I'll certainly, Mary, I'll ask you a question about that here in a minute. First, Judge Peck, Judge Ambry noted that discovery in this case was originally limited by the law enforcement investigatory privilege. How does that privilege work?
It's a common law, judge-made law provision to not let discovery in civil cases interfere with criminal prosecutions or criminal investigations. So it is not uncommon for a court to stay all or certain discovery in the related civil case to avoid interference with the criminal case. It's also not uncommon for a party in the civil case to say, as long as there is a criminal proceeding which may be targeting me, if you take my deposition in the civil case, I'm going to have to take my Fifth Amendment protection against self-incrimination. So don't let my deposition go forward either. So it affects both sides, the civil plaintiff, the criminal defendant, the criminal investigatory agencies, but it is up to the judge in each particular case whether to invoke it, or as in here, to have it invoked for a while and then have it disappear.
Mm-hmm. Okay, very interesting. So, Mary, as we were just discussing with Tom, we've had discovery pilot projects in Arizona and Illinois, and apparently in Texas as well. And as far as we know, that's it. So why do you think more states haven't created pilot projects to expedite discovery?
Oh, well, I think that for some stakeholders, slower discovery is a feature and not a bug. So there's that. And cooperation is still evangelical, I think. And in terms of mandatory disclosures, I mean, I hope people aren't considering them as discretionary and not mandatory. But, I think that part of the federal rules has not gotten the support in general. And then I do believe that the judges need to volunteer, so they have to have time to volunteer. You need some staffing and resources. You're actually changing things, so systems and processes needed to be changed to track, to accommodate. And then I think there's a sense that a lot of cases will settle before trial, so why invest in early discovery? So for all of those reasons, I think the pilot projects, they just didn't replicate.
Yeah, makes sense. I will have to remember that line. Most people think slow discovery is a feature, not a bug. That's I love that. So that's a good one. But we'll move on to our next case, which involved a dispute over a restaurant joint venture where defendants' counterclaimants filed a motion for the issuance of letters rogatory to the appropriate authority in France to compel the production of documents from non-party company Next Stage. In beginning his ruling on the decision, New York Supreme Court Justice Robert Reed stated, in all cases involving international discovery, the court should take into account the importance of the information sought to the litigation, the degree of specificity of the request, the availability of alternative means of securing the information, the extent to which noncompliance with the request would undermine important interests of the United States, or whether compliance with the request would undermine important interests of the state where the information is located. It is well known that the scope of American discovery is often significantly broader than is permitted in other jurisdictions. Therefore, a number of courts, as well as the restatement, have said that a more stringent test should apply in international discovery than in purely domestic discovery. In order to compel the production of discovery from international entities, therefore, the movement must first establish that the sought information is crucial to the resolution of a key issue in the case. As for the defendant's request, Judge Reed stated, here defendants assert that the documents sought are material and necessary to the prosecution of this action because they provide information about the investment that Next Stage made in the Bagatelle family of companies who are purportedly counterclaim defendants in this action. Defendants submit that it is necessary and convenient to issue a letter rogatory. Convenience is not the standard. Defendants fail to show how its requests differ from anything it could have requested from counterclaim defendants directly, or how the information already obtained from counterclaim defendants failed to include this vital information. In denying the motion, Judge Reed stated, defendants have not pointed to any deficiencies in production and have not established how information regarding a third-party international investment is crucial to the resolution of a key issue in this case, namely improper transfers between counterclaim defendant entities. So perhaps the use of the word convenient was the French kiss of death for the defendants in this case. So, all right. Anyway, so Judge Peck, information about the investment that Next Stage made in the Bagatelle family of companies who are purportedly counterclaim defendants in this action sounds like pretty important information to me. What, if anything, could the defendants have done to request the information needed to get the order granted in this case?
Well, I think, the key thing is the reference to it has to be crucial, not just necessary or useful or any of that. And that does come from the aerospatial line of cases, but that crucialness test is too often ignored by the courts. Here, I think, it's not so much what they could have done other than avoid words like convenience in their application, to get it from the foreign entity, but it's not clear to me why they couldn't get this discovery from domestic sources. Why couldn't they get it from the Bagatelle group of companies who were counterclaim defendants, or even if not, related parties in the US? So seems to me that unless they were able to show, as they apparently didn't here, that Bagatelle was playing games in discovery, was asked for it and didn't provide it, or anything along those lines, they haven't done what was necessary to satisfy the crucialness test.
Sure, makes sense. So Mary, certainly we see more cross-border discovery and international-oriented cases. So what recommendations do you have for our audience and best practices for handling discovery when international parties or related third parties are involved?
Well, talking about the international, it's like technical competence. It's important to either know it yourself or have experience guidance, boots on the ground in the jurisdiction, if you will. So, understanding what the practices are. And then phasing the international piece and the third party, related third party piece, so that that is at the end rather than at the beginning. But of course, you'll want to meet and confer, get something in your scheduling order, educate and assess what the judge would be willing to allow or not allow. And then you can also look for the data that you want, especially email, social media, things that would probably be considered personal information from more public sources or sources that are in your jurisdiction already and don't have to be transferred. And I might add that the GDPR project at EDRM has released some guidelines that are freely available on the EDRM website, on the project page. And there's some judicial training that's being developed by that project, and they'll be reporting out at Relativity Fest during the EDRM session.
Okay, all right, yeah, and so folks who are going to be there should look for an update from them, and definitely very intriguing project that EDRM is working on. So Tom, Judge Reed made specific reference to the defendant's use of the word convenient in his order. Do you think the way they worded the request factored into the decision, or would it not have mattered?
Oh, I think it would have mattered. Judge Peck just pointed out, not a great use of terms, and the judge specifically said convenience is not the standard. So when you use convenient in your pleading, I think you're falling short there. You got to show something that's crucial. The judge laid out what the standards were, what the standard is, and convenience isn't it. So yeah, I think the wording definitely factored into the decision, and better wording may have had a different result. Although the judge said something similar to what Judge Peck also said, which is, how come they didn't get this from, the counterclaim? Did you have to go to France to get this? Seems like everybody asked that question as well.
Yeah, which is a very appropriate question to ask. So certainly sounds like they could have made a better case for this information. And with that, we'll move on to the next case. And hey, I mean, we know Judge Peck loves cases involving technology-assisted review disputes, and he loves cases involving 502D orders. So it's not any surprise he suggested this case, which has a little bit of both. Here, the court addressed disputes regarding issues related to two protocols, the clawback provision of the protective order and the TAR provision of the ESI protocol. Regarding the clawback provision, the plaintiffs argued FRCP Rule F02B is expressly titled Inadvertent Disclosure and provides a safe harbor for inadvertent production if reasonable steps were taken to prevent the error and then rectify it. They also expressed concerns that defendants' proposal would eradicate the waiver consequences of an intentional disclosure and indicated that they expected defendant Teva might attempt to use the inadvertentless clawback provision to allow reassertion of privilege over emails Teva intentionally produced in the EpiPen MDL to keep him out of this case. Defendants argued that their proposed clawback provision for all materials, whether inadvertent or otherwise, was consistent with FRCP Rule 502D. Kansas Magistrate Judge Teresa James ruled the court finds defendants' proposed provision preventing the clawback of privileged materials on any basis, whether inadvertent or otherwise, will avoid disputes over whether the party's disclosure was inadvertent, adding that the plaintiff's concern can be addressed through motion practice challenging the assertion of privilege for the specific documents. For the TAR dispute, plaintiffs proposed this ESI protocol provision. If a producing party intends to use TAR to cull documents for review and production after a good faith attempt to produce from the search term protocol, the producing party shall disclose the need for implementation of TAR. The parties shall then meet and confer to enter into a cooperative and transparent TAR protocol. Defendants objected and proposed this. The parties shall meet and confer to enter into a mutually agreeable TAR protocol. Judge James ruled on this issue, stating, both sides make valid arguments, but the court finds plaintiffs' proposed TAR provision to be the better choice. The court finds persuasive the cases cited by plaintiffs, noting the importance of transparency and cooperation among counsel when a party intends to use TAR. According to those cases, TAR requires an unprecedented degree of transparency and cooperation among counsel in the review and production of ESI responsive to discovery requests. Those cases also note that courts approving the use of TAR typically require the producing party to provide the requesting party with full disclosure about the TAR technology used, the process, and the methodology, including the documents used to train the computer. Plaintiff's TAR provision better aligns with these principles of transparency and cooperation, as it requires the party intending to use TAR to disclose the need for implementation of TAR, as well as requiring a meet and confer to enter into a cooperative and transparent TAR protocol. The court does not find the word transparent ambiguous in this context. She did recognize that requiring a party intending to use TAR to make a good faith attempt to produce from the search term protocol before implementing TAR was unclear as to what that would entail, but declined to craft language regarding that, instead reminding the parties to apply a reasonableness standard. So Mary, Judge James referenced the cases that plaintiffs cited as persuasive, but didn't mention any cases cited by the defendants. So they either didn't cite any or the cases weren't impactful enough to mention. Do you think they dropped the ball on including notable cases in their arguments?
Well, absolutely. I think that they did. Yeah, I agree that they weren't memorable enough to mention if they were there. And it may be, though, that they just thought it was like settled practice and law that Sedona Principle 6 controls that, the producing party is best suited to determine the production process. And here it's clear it is not settled.
Yes, it doesn't appear to be settled, and certainly it seems like they could have cited Hiles, which a famous judge ruled on, as I recall. So that might have been a good one to get into Sedona Principle 6. So, Tom, Judge James stated that TAR requires an unprecedented degree of transparency and cooperation among counsel in the review and production of ESI responsive to discovery requests. Do you agree with that?
So seriously, you want me to publicly state that the judge is wrong, and I totally disagree with your interpretation? I mean,
I just am asking the questions, man.
I know it's only the second case of the day here, but come on. Not only Judge James, but the three cases that she refers to as citing that same proposition. So discretion is the better part of valor, and I'm going to say the judge got it absolutely right.
Okay, all right. I could say don't get me started, because I don't know why TAR is so much more suspect than search term and manual review, but that seems to be the way a lot of people in the legal industry think about it. So for whatever that's worth. So Judge Peck, I've got two questions for you, because they really just want to get your opinion on both of them. So first off, the defendants won the argument regarding the clawback provision by proposing a provision that was consistent with Rule 502D. But does the lack of an actual order leave them vulnerable if the plaintiffs want to appeal the ruling to a higher court?
Well, this is a magistrate judge decision, so the only quote-unquote appeal is to file objections to the district judge within 14 days of the magistrate judge's order. Presumably, whether this decision constitutes the order or whether the signing off on the ESI protocol containing the 502D language would be the order. One or the other would give you the right to go to the district judge if you were foolish enough to do that about the 502 type language. And I would just note that in order for 502D to be effective beyond the very case as just an agreement of the parties, and here the parties didn't even agree, it has to be a court order. Something else, a stipulation or whatever, does not suffice. So I would clearly say that Judge James got it right on the 502D provision.
Mm-hmm. All right. Well, now let's ask if she got it right on the other thing. So, Judge Peck, do you agree with Judge James' ruling that a party be required to make a good faith attempt to produce from the search term protocol before proceeding with TAR?
Unlike Tom, I have no fear in saying a judge screwed up. I think
unlike Tom, your name starts with judge.
Yeah, well, but it's got that, RET at the end of it.
Yeah,
so.
well, it's still.
And I'm going to be in Kansas City for Nellie in 2 days.
Yeah, there you go.
So I'm within Judge James's jurisdiction. She's not on our panel this year, but she has been in the past. I know her, but she's wrong. First of all, a lot of the cases she cited about cooperation and all of that were from the early days of TAR 1.0, when we were all trying to figure out what TAR meant and how it was going to work. All the studies from Maura Grossman and others show that TAR is at least as good, if not better, than search terms and manual review. We are no longer pretty much ever, but certainly not in regular litigation as opposed to Hart-Scott-Rodino second requests, in a simple TAR 1.0 where you have to train the TAR process, etc. Right now, most TAR is continuous active learning. So initial training is much less important, probably not important. And saying you got to try to use the search term approach before you can use TAR is pretty much saying you're not going to use TAR, because if you've gone down the road of using the search terms, you've already spent the time and money that you're trying to save using TAR. So I think Judge James was not, shall we say, adequately informed by defense counsel here, and as a result of that was led astray by plaintiffs.
Yeah, certainly seems so, and definitely surprising to see that we're still finding decisions like this. Obviously, the party proposing to use TAR, if there's a lesson learned here, it better kind of get their ducks in a row in terms of their argument and not assume anything. So, all right.
I knew you'd bail me out there, Judge.
Yes, indeed. So on to our next case, where the level of security needed to protect health data that's turned over to the government in discovery, and who should pay for the cost of that security was at issue. The government had already proposed a robust set of protections for the data that was high trust certified, and the monthly cost already being incurred by the government for this level of security was about $5,000 a month. Anthem requested additional protections, which would cost an additional $4,300 a month, including tracking and logging of all activity on the platform, monitoring of internal activity logs, and more, contending the additional measures were consistent with industry standards and with applicable regulatory guidance. Noting that one of the government's vendors experienced a ransomware attack that compromised some of Anthem's data, resulting in the vendor having to send notice to impacted individuals, pay for 2 years of credit monitoring, and a lawsuit, and stating accordingly, Anthem is rightfully concerned about the protection of its data in this case, New York Magistrate Judge Catherine Parker identified 4 non-exclusive factors as relevant to determining whether there's good cause to shift all or a portion of cost of data security measures. Regarding the first, nature of the information, Judge Parker said, given these risks, and particularly given the previous breach, Anthem's concern for the security of the data is reasonable, and this factor weighs against shifting the cost of that security to Anthem. For reasonableness of security measures, she stated, it is not clear how much additional risk will be mitigated from the additional measures proposed by Anthem. Ultimately, the only technical opinion offered by the parties is from Anthem's head of cybersecurity threat management, whose declaration identifies specific vulnerabilities in the government's proposal. This factor also weighs against shifting the cost of data security to Anthem. Judge Parker also considered the cost of the additional security measures relative to the amount in controversy, which was in the millions, and stated this factor also weighs against shifting the cost of data security to Anthem. And while she did find that the relative ability to pay weighed slightly in favor of shifting the cost of data security to Anthem, it wasn't enough to offset the other factors. So she ordered the government to pay additional security costs to protect that PHI data, but also stated, however, this decision is without prejudice to a renewed motion under Rule 26 to shift the cost of this enhanced security if defendant engages in conduct that unreasonably extends discovery so as to increase the cost to plaintiff. So, Tom, do you think it's fair for the government to pay for additional security protections that Anthem requested?
Well, fair? I'm not sure fair is the right adjective there, but I thought the judge did a really good job of diving into those 4 factors, weighing everything, really well-reasoned investigation of it, and even saying, the last one, the relative ability to pay, may have weighed slightly in favor of shifting it to Anthem. But, I just thought it was a well-reasoned decision based on what was there. And as you just noted at the end, well, I'm also leaving this open to a renewed motion under Rule 26. So if this drags out and it looks like it's going longer due to something that Anthem is causing to extend the case, then we'll, you can revisit the issue with me. So,
right. Well, yeah exactly, which is certainly appropriate. And
Yeah.
I think Judge Parker also noted that, I mean, I guess depending on how the case is decided, this could be included in cost recovery. So
Yeah.
the government, which technically is us, paying for this may not be, permanent, depending on how the case goes. But yeah, we will see, and definitely was well reasoned. So, Judge Peck, you think if the government had provided its own expert technical opinion to counter Anthem's expert on stated vulnerabilities, do you think it would have made a difference?
It certainly couldn't have hurt. If one side has expert opinion and the other doesn't, unless that expert, was smoking something and doing their report, the court is obviously going to give that some weight. But, to a certain extent, the parties seem to be arguing about costs or cost shifting more than whether this was technically necessary. So perhaps having an expert would not have changed anything. I do note that Judge Parker clearly stated that, quote, the issue of data security and discovery and how costs should be allocated for same is one that does not appear to have been addressed in any other court decision, close quote. So this is really a very, very important decision and will probably have implications not in, government actions where health data, but, private antitrust actions, perhaps, or even, employment discrimination cases where the plaintiffs' firms tend to be smaller and perhaps do not have sophisticated security in place. And I think that as more and more firms suffer data breach, that is going to be something we're going to be seeing a lot more litigation about.
Yeah, I couldn't agree more. And I'm surprised that this is kind of the first decision where, this issue's really been addressed in terms of a case law ruling. But yeah, I mean, this is an issue that's going to continue to come up again and again. And certainly this case will factor into, kind of those considerations. So very important ruling there by Judge Parker. So Mary, PHI is perhaps the most sensitive form of personally identifiable information. So what recommendations do you have for our audience to ensure, or at least ensure to the extent possible, such sensitive data is protected during discovery?
Well, there's a few things to do. The first, of course, is a protective order and making sure that all staff is trained and any contractors as well. Employing encryption at rest and in transit during transfers, and making sure that the systems themselves are secure with access control, granular access control. The data itself, the evidence itself, you can consider anonymization or pseudonymization, certainly, or redactions, like in bulk on the intake. And then on production, making sure that those redactions still hold and that there are endorsements on the sensitive nature of the evidence. And then QC the load files as well. There's nothing like doing redactions and having the extracted text still have what you just redacted in it. And then, of course, review your access logs.
Yeah, absolutely. And hey, years ago, I got burned with some redacted text that made it through a load file. So yeah, definitely, you can't be too careful with that. And certainly another thing I would throw into the mix, and those were all great suggestions, Mary, is consider. I think the platform you're using, a lot of them have different levels of security, certifications and what have you. And I think those are indications that, in terms of agencies and what our expectations are and what have you. So, kind of be aware of what your platform, touts in terms of security, especially if you want to use it for certain things like government cases where there are specific requirements and what have you. So, I would throw that into the mix as well. And we'll move on to our next case, which involves alleged False Claim Act violations for allegedly ordering unnecessary PCR urine tests for patients. And the U.S. proposed a plan to address the issue of attorney-client privilege in connection with the defendant's production of documents. Plaintiff asserted that U.S. proposed entering an order under FRE 502D, which would have protected the defendants from any potential waiver. The defendants asserted that the U.S. did not propose a Rule 502D order, but rather offered to use a filter team to screen out defendants' privileged documents. As Massachusetts Magistrate Judge Donald Cabell stated, regardless, it is undisputed that the defendants rejected the proposal. Instead, the defendants conducted their own internal privilege review before producing documents to the United States. That apparently didn't go so well. The U.S. informed the defendants that it had identified 12 potentially privileged documents while reviewing a defendant's production, and subsequently identified a few more, and the defendants conducted a review and clawed back the 12 documents that the U.S. had identified as potentially privileged, but did not review the rest of the production or any other production to see if they had inadvertently produced any other privileged documents. After settlement discussions for months and an eventual settlement with the U.S. and the plaintiff entered into a common interest agreement to facilitate the sharing of information and materials between them, and the U.S. provided the plaintiff with the documents that the defendants had previously produced to the U.S. The defendants didn't learn that the U.S. had provided their past productions to the plaintiff until the plaintiff used documents from one of those productions as exhibits during a deposition, after which the defendants attempted to claw back 639 allegedly privileged documents, which was eventually reduced down to 613 after the plaintiff objected and the parties conferred. After rejecting the plaintiff's argument that defendants waived the privilege by putting privileged materials at issue in litigation because those claims had already been dismissed, Judge Capel had then proceeded to consider implied waiver and identified 5 factors for inadvertent disclosure that constitutes a waiver. Finding that 4 of the 5 factors for inadvertent disclosure weighed in favor of waiver, including the fact that the defendant and not its counsel conducted the privilege review, and a delay of well over 2 years and 7 months to disclose the inadvertent disclosure, Judge Cabell found defendants had waived privilege on those documents. So Judge Peck, given that the privileged documents were out in the open for over 2 years, would a Rule 502D order still have helped the defendants in this case?
Certainly can't hurt. Indeed, I would say, as I have before, it is akin to malpractice not to seriously consider getting a 502D non-waiver order. I mean, out in the open just means, it was floating around in the government's files. It's not like it was being published in the New York Times or anywhere else. So if one had a 502D order, the question of reasonableness of the production and prompt seeking to get it back, and all of that pretty much disappears. If it's a privileged document, you didn't intend to waive it, it's not a waiver, and then you can fight about whether the document is covered by privilege or not. I think parties should have a 502D order in every case, certainly every case that is symmetric. Maybe the asymmetric case where the plaintiff doesn't have privilege documents, it's hard to get the plaintiff to agree to a 502D order, not that the parties have to consent. One other point I would point out, which is that typically a 502D order is forward-looking. So if you've had a government investigation where you didn't have a 502D order in place because there was no judge to sign it, you probably, once that becomes a litigation, can't use a 502D order to retroactively protect whatever waiver may have occurred beforehand. But, if you take nothing else from any time you hear me talk, it's get a 502D order.
Yeah, absolutely. Yeah, and great point about the fact that it's not retroactive, but it is forward acting and certainly could apply to other cases that this defendant could be involved in. So, very important in that regard. So, Mary, what do you think about the fact that the defendant itself and not its counsel conducted the first pass privilege review? Is that a good idea or a bad one?
Well, all sorts of people and things do a first pass privilege review. We sometimes have machines do it, and sometimes we have contractors doing it, but there's generally a second pass. So I think them doing it takes the costs down quite a bit. They probably know the material very well, but sometimes something more arm's length might be indicated. Certainly during criminal or quasi criminal, that the company situations involved executives who may be witnesses. It may be better to have the execs stand down. Plus, they want to be running the business.
Yeah, they do. They do need to be doing that. So yeah, it certainly seemed to influence Judge Cabell's decision here. The fact that they did it, and certainly QC, it should have been maybe clearly more stringent. So, Tom, settlement discussions for months was given as a potential reason for why the defendants dropped the ball on producing privileged documents. So what recommendations do you have for our audience to avoid mistakes like this when settlement discussions are going on?
Well, I'm not sure why settlement discussions for months would lead to an issue. It would seem like the longer the time frame this was going on, the better a handle you could get on things, the more time you had to get a handle on things. I mean, the big thing here was even after they were told there were 12 documents, as you said right in your middle point there, they didn't review the rest of the production or any other productions to see if they had inadvertently produced any other privileged documents. I mean, this just seems like a sloppy review process. And so, a stringent process, put somebody in charge of it, have QC, check and double check. And yeah, get a 502. I mean, come on. Again, it would seem to me, maybe I'm wrong here, but it would seem to me the longer time frame you had, the more you should be able to deal with this instead of having a really short porch where you had to produce things quickly and we're under the gun. So
yeah, and I think if the defendant was going to say, well, we don't want to spend the money to re-review the production for privilege while we're talking settlement, it probably would have been a good idea to put that in writing and send it to the plaintiff or the government or both. So it's not looking like an after the fact, how do I solve the dilemma? I mean, let me say I didn't do it because of privilege, because of settlement discussions. No,
it was dragging out. Yeah.
Put it out there.
Yeah, absolutely. Certainly, we try to cover cases like this, so there can be lessons learned, and there's definitely several lessons learned from this one in terms of how the defendants could have handled things better. So, with that said, there we go. We can't go a whole webinar without at least one case involving spoliation of evidence, and this one's kind of a doozy. Here, the plaintiff was placed on administrative leave and eventually resigned after raising concerns about a security vulnerability in a transit software system. As the case progressed, the CTA filed a motion for sanctions, arguing that the plaintiff failed to preserve three categories of relevant ESI you see there in the three sub-bullet points. The first was that the plaintiff deleted all pre-November 2, 2018 messages exchanged with his supervisor, Haynes, claiming the deletion happened when Haynes deleted his Signal thread with plaintiff, causing plaintiff's own messages with Haynes to disappear. When CTA obtained an affidavit from the chief operating officer of Signal, however, stating that has never been a feature, the plaintiff changed his explanation for the deletion of his messages, based on Haynes' message deletion, claiming his Signal application was coded to delete any such potentially compromised conversations. Finding intent to deprive Signal messages, Illinois District Judge Robert Gettleman stated, the court concludes that the pre-November 2, 2018 messages are relevant ESI and should have been preserved. The court also concludes by a preponderance of the evidence that not only did plaintiff failed to take reasonable steps to preserve the pre-November 2 messages, but he intentionally destroyed them. The court independently determines that plaintiff's explanations for the deletion of these messages are not credible. The plaintiff also enabled the disappearing messages function on a Signal application to delete messages 24 hours after they were read, which caused the second category of spoliation you see there. While Judge Gettleman found these messages to be relevant, he stated, the court agrees with plaintiff that the record does not contain enough evidence to suggest that plaintiff spoliated the second set of messages via the disappearing messages function for the purposes of hiding adverse information. The third one was a bit wild. A forensic image, in quotes, of plaintiff's phone conducted under the direction of his attorney Duffy contained only 0.2 gigabytes of user-generated data. Duffy represented to CTA in the court that this first image was a complete forensic image of the phone. However, after a court order compelling a second imaging, CTA's retained vendor produced a second forensic image of plaintiff's phone, and that image contained 25 gigabytes of unique data, including 42 recovered Signal messages between plaintiff and Haynes, exchanged between May 2019 and October 2019. Those messages were not included in the first image and were highly relevant to the litigation. So Judge Gettleman stated, the court concludes that plaintiff failed to preserve his cell phone with intent to deprive defendants of its contents. After the first image, Duffy repeatedly misrepresented to CTA that plaintiff obtained a complete image of his cell phone and repeatedly failed to correct his misrepresentation. So Judge Gettleman not only adopted the recommendation to dismiss the case, he also imposed significant monetary sanctions that you see there to the tune of over $37,500 to the plaintiff and over $112,000 to plaintiff's counsel Duffy, whose first name is never mentioned in the ruling, even though his last name is mentioned 64 times, which he's probably glad about. So, Mary, are you surprised that Judge Gettleman failed to find intent to deprive regarding the post-October 2019 messages as well, given that we've covered other cases where failure to turn off automatic deletion resulted in that finding? Do you think he would have ruled differently on that issue if there wasn't a finding that the other messages were intentionally deleted?
Well, I think this is a poster case regarding intent to deprive, with the reason of wanting to minimize the data for hygiene, not necessarily to affect the case, because what was written in the opinion is plaintiff argues that he turned on the disappearing messages feature for the purposes of data hygiene and to maintain storage, and that there is no specific evidence in the record to refute that statement. So I think that's the reason. You needed something to hang it on.
Yeah, and I'm not sure if I can. I don't recall seeing in the ruling anywhere specifically when he turned on the disappearing messages function, because one of the things we've seen, of course, is turning it on once there's a case is bad news. But if you already had it going before a case is filed, that's different. So, but yeah, that's it. Certainly seems like he gave the plaintiff the benefit of the doubt, at least in that area. So Tom, I've heard you cite Hanlon's razor to never attribute to malice to that which is adequately explained by stupidity a number of times. So which attribution do you think is appropriate for Duffy's counsel regarding Duffy as counsel regarding the first forensic image?
Well, I think the court answered that question pretty adequately, right?
Right.
He had motive to hide information. He repeatedly misrepresented that they had a complete image, and then repeatedly failed to correct that misrepresentation. So, I mean, the judge just brought the hammer down on what, whether it was malice or stupidity, it was intent, it was deliberate intent, and misrepresentation about what had occurred. Plain and simple.
Indeed. And Judge Peck, I mean, with the total fees and costs assessed to plaintiff's counsel Duffy being over $112,000, given the judge's finding of evasive tactics and dishonesty, should he be facing potential disbarment as well?
I guess it depends on who's going to turn him into the disciplinary authorities. Judges, I think, hate to send a lawyer to the state disciplinary board. Maybe if the Northern District of Illinois, and I assume they probably do, has an internal disciplinary authority, maybe even there, particularly while the case, I guess the case is now over other than appeal, but while a case is pending to turn someone into the disciplinary authorities, I think many judges would be reluctant to do that. I will note that, this is a single plaintiff case. 112,000 and change is probably more than more than what could be collected even over years from Mr. Pable. So if the attorney's fees were not recoverable from counsel, who presumably has, other cases that are getting him or her money, it's a sort of Pyrrhic victory to go tell the client, yep, we got, $1 million of sanctions or 112,000 in sanctions against the plaintiff. Oh, that's great. Where and how are you collecting it? Well, probably
Right.
we're not. So the attorney is often the deep pocket in this situation, which is generally a good thing, although obviously I'm sympathetic to counsel.
Sure. But yeah, it certainly seems appropriate here. And I'm curious if the failure to mention Duffy's first name was intentional or not, but that seemed very odd. That I went through the case twice thinking it's got to be here somewhere, but never did mention his first name. So regardless,
I
now
would,
it's on.
Doug,
Oh, go
sorry,
ahead.
I would note that at least one or two of my former district judge colleagues would have written this opinion without naming the attorney at all.
Oh, okay.
So,
Interesting.
It depends.
Yeah.
Gotcha. Okay. Duly noted. So now onto the contacts page in our next case law webinar. As Kaylee mentioned, be afraid, be very afraid. It's on Halloween, and we'll have plenty of tricks up our sleeves and treat you with terrific legal and eDiscovery best practices. So come on, I had to end with one. So with that, I will say thanks to Mary, Tom, and Judge Peck for their terrific insights as always, and I'll turn it back over to you, Mary.
Well, thank you, Doug, for anchoring. And thank you to Tom O'Connor and the Honorable Judge Peck for this great discussion. Our thanks to the EDRM community for your kind attention. If you really loved the discussion, show Honorable Judge Andrew Peck, Tom O, and Doug Austin from Houston some love. Find your emojis at the bottom of your console. And to be automatically registered for on-demand webinars, click the pop-up at the conclusion. Once there, click the bell to subscribe for updates. And we'll see you next time on the EDRM Global Webinar channel. Thank you.
Thanks, everybody.
Thanks.
Bye all.
Bye-bye.